Welcome to the deep dive. Imagine this. You shake hands on a deal, maybe buying something simple, say, for $80. Seems straightforward. But then, moments later, the seller backs out. Why? Because they just found out that simple thing is actually worth, I don't know, nearly $1,000. Today, we're digging into that exact scenario. When can a mistake, a really fundamental mistake about what something is, let you just tear up a contract? We're looking at that razor-thin edge between a mistake of substance and just a mistake in quality or maybe bad judgment.
Yeah, it's a really fascinating corner of contract law because, there's this tension. On one hand, the law wants contracts to be stable, final. Commerce depends on that. But on the other hand, what happens when both sides were just completely wrong about a key fact? There has to be some room for fairness, right? So our path today is going to zero in on one specific doctrine, mutual mistake. We'll lay out the basic rule, pin down the elements you absolutely have to prove, and then really dissect the classic case, Sherwood v. Walker. It's an 1887 case, but it still sets the standard for this substance versus quality issue.
Okay, let's start unpacking that. So, two people make a deal, but they're both wrong about something really important. What's the basic legal idea that lets them maybe get out of it?
Okay, the general rule goes like this. If you agree to a contract, but your agreement was based on a mutual mistake about a material fact, you might be able to refuse to go through with it, or even undo it, rescind it, after the fact. But, and this is the crucial part, the mistake has to be about the substance of the deal, not just some feature or quality. The law generally doesn't rescue you from a bad bargain. It steps in when the very thing you thought you were dealing with turns out to be fundamentally different.
Right, that substance versus quality thing. That sounds like where all the arguments happen. Like, if I think I'm buying a 20-carat diamond and it's only 18 carats, okay, that feels like quality. But what makes something a mistake of substance? Does it have to be like a totally different category of item?
That's exactly it. And to figure out if a mutual mistake defense holds up, we have to check off three essential elements. Missed any one, and the contract probably stands. First, the mistake has to be mutual, shared by both sides. Can't be just one person who was wrong. Second, it needs to be about a material fact, something important enough that it significantly affects the value or the whole reason for making the deal in the first place. And third, this is the big one from Sherwood, the mistake must concern the substance or the very nature of the thing being contracted for. It has to go to the root of the matter.
All right, let's put these elements to the test with the famous cow, Rose Tekken of Aberloan. We'll use Sherwood v. Walker to see how this works in practice. First off, what are the legally dispositive facts?
Okay, the facts seem pretty simple on the surface. You've got the defendants, the Walkers. They're breeders of high-end cattle in Michigan. They agree to sell a specific cow, Rose Tekken of Aberloan, to the plaintiff, T.C. Sherwood. He's a banker, also does some farming. The price agreed upon is 5.5 cents per pound. Based on her weight, that works out to about $80. Now, the key fact, both Sherwood and the Walkers believed Rose was barren, sterile, couldn't breed. So essentially, she was being sold as beef.
And wasn't there some history there, like the Walkers had actually tried to breed her before, right? Which is why everyone assumed she was barren.
Exactly. That shared belief wasn't just casual, it was based on past experience. They thought her breeding days, if she ever had any, were long over. But then, before Sherwood comes to pick her up, the Walkers discover, surprise, Rose is pregnant. This completely changes things. She's not just beef value anymore. She's a valuable breeder cow worth somewhere between $750 and $1,000. A huge difference. So when Sherwood shows up, the Walkers refuse to hand her over. They try to back out of the deal, arguing essentially, this isn't the cow we agreed to sell.
Okay, so that sets up the conflict perfectly. What was the core legal issue that the Michigan Supreme Court had to decide?
The precise legal question was this. Was the shared mistake about Rose's fertility a mistake of substance, meaning it went to the fundamental nature and value of the deal, allowing the Walkers to rescind? Or was it merely a mistake about her quality, in which case the contract would still be binding?
Got it. So what role of law did the court, specifically the majority opinion written by Justice Morse, use to figure this out? Can you state the rule they applied and break it down into those testable elements again?
Sure. The majority laid down this rule. A contract can be voided if the thing actually delivered or received is different in substance from the thing the parties bargained for and intended to sell. And based on their reasoning, we pull out those three key elements for analysis. 1, was there a mutual mistake? 2, was it about a material fact? And 3, did that mistake go to the substance or nature of the thing?
Thank you. Okay, now let's dive into the court's elemental analysis, step by step. How did the court apply that first element, mutual mistake?
This part was pretty straightforward for the court. They found it was clearly mutual. Both the buyer, Sherwood, and the sellers, the Walkers, operated under the exact same uh, mistaken belief that the cow was barren. The price itself reflected this shared mistake. $80 is beef price, not breeder price. If one side knew the truth and the other didn't, well, that's a different story. Maybe fraud, maybe just taking a risk. But here, both were wrong. So, element 1, mutual mistake, check.
Understood. Now, what about the second element, material fact? I mean, okay, the price difference is huge, $80 versus maybe $1,000. But isn't the point of contract law to lock in the bargain even if one side gets lucky? Couldn't the court have just said, look, a deal's a deal, 5.5 cents a pound, sometimes you win, sometimes you lose?
That's definitely the counter-argument, and it touches on the policy of finality. But the court found the mistake was overwhelmingly material. It wasn't just a minor fluctuation in value. It was, as you said, almost a tenfold increase, maybe more. The court reasoned that the parties simply would not have made this specific contract at this price if they hadn't believed she was barren. That belief was essential to the deal. So it wasn't just incidental. It was a core material fact driving the agreement. Element 2, material fact check.
Okay, and now the big one, the core of the Sherwood decision. The third element, mistake of substance, very nature of the thing. How did the majority justify saying that a pregnant cow is substantially different from a barren one? They're both cows, right?
Right, and this is where the court draws that crucial line. They argued it wasn't just a mistake about quality, like maybe she weighed more or her coat was nicer than expected. No, they said this went to her very nature. They declared that a barren cow is, in essence, a different kind of creature for commercial purposes than a breeding cow. The famous quote is that the difference is as much difference between them as there is between an ox and a cow. An ox pulls a plow, a cow gives milk and calves. Different functions, different natures in their view. Since the parties only intended to contract for a barren beef animal, the court concluded that the thing they actually bargained for, that specific kind of cow, effectively had no existence. What existed was something else entirely.
Wow, okay. So no existence is strong language. It's not just that she was better, but that the intended item literally wasn't there.
That's the heart of the majority's reasoning. The beef cow they agreed upon didn't match the reality of the breeder cow that stood before them. So element 3, mistake of substance, check.
And with all three elements satisfied, mutuality, materiality, and substance, what was the court's final conclusion?
Conclusion. The lower court's decision, which had enforced the sale, was reversed. The Michigan Supreme Court held that because the mutual mistake went to the substance of the whole consideration, the Walkers, the sellers, had the right to rescind the contract. They didn't have to deliver Rose Toucan for $80.
Okay, but this is where it gets really interesting, like you said, because it wasn't a slam dunk. There was the dissent, right? Justice Sherwood, same last name as the plaintiff, interestingly had a completely different take. What was the core of the dissent's argument? How did they see the substance versus quality issue?
Yes. The dissent, led by Justice Sherwood, fundamentally disagreed. Their view was much more grounded in, let's say, caveat emptor buyer beware, or maybe seller beware in this case. Justice Sherwood argued there was no legally relevant mistake of fact here. He emphasized that the specific cow sold, Rose Toucan, was the exact same cow the Walkers were refusing to deliver. Her identity wasn't mistaken. The mistake, in the dissent's view, was purely about her quality, or her condition specifically, her capacity to breed. He basically suggested that Sherwood, the buyer, maybe just made a better judgment call, or perhaps was willing to take a gamble that she might be able to breed, even if the sellers thought she couldn't. There was no fraud, no concealment alleged.
And the dissent used a really potent analogy involving a horse to hammer this point home, right? Can you lay out that hypothetical? It really helps clarify their perspective.
Absolutely. The Hambletonian horse hypothetical is key to understanding the dissent. Imagine someone sells a fancy trotting horse for $300. The seller believes the horse's top speed is, say, a mile in 3 minutes, respectable, but not amazing. The buyer, however, thinks the horse might be faster. Turns out, the buyer was right. The horse is later clocked at a mile in 2 minutes, 16 seconds, making it a champion racer worth maybe $20,000. The dissent asks, can the seller undo the deal just because their judgment about the horse's quality or potential was wrong? Their answer is a firm no. That, the dissent argued, is a mistake in judgment, not substance. The parties took their chances on the horse's potential. A sale doesn't automatically guarantee any particular quality unless it's explicitly warranted. They saw the Rose Toucan situation as exactly parallel.
So the dissent is really pushing back hard on the majority's framing. They're saying, look, it was the same cow, her potential turned out to be different, but that's a risk inherent in buying and selling living things or things with unknown qualities.
Precisely. The dissent saw it as a difference in attributes, perhaps value, but not identity. The majority saw the attribute fertility as defining the identity or nature of the thing for the purpose of the contract. That's the crucial split.
Okay, so let's crystallize this. For someone listening, maybe facing a contracts exam or just trying to grasp this concept for real-world deals, how do they use Sherwood? How do they spot this issue and structure an analysis based on what we've discussed?
Right, Sherwood gives us the clear framework. It's really about applying that three-element test methodically, just like the court did. Here's a step-by-step approach. Step 1. Identify the mistake in mutuality. First question. Were both parties mistaken about the same essential fact, and did that fact exist at the time they made the contract, not something that changed later? If yes, move to step 2. If no, the mistake defense probably fails. Right there. Step 2. Assess materiality. Okay, assuming it was mutual, was the mistake about something important? Did it significantly affect the value, or would the parties, acting reasonably, have likely not made the deal at all if they knew the truth? Think Sherwood. $80 versus $1,000. That's material. A minor difference probably isn't enough. Step 3. Test for substance versus quality. The Sherwood test. This is the core battleground. Ask, does the mistake mean the thing they contracted for is fundamentally different in its kind or nature? Use the majority's ox versus cow analogy. Is it a different category of thing? Or is it more like the dissent's horse hypothetical, the same thing, just with a different quality, grade, value, or potential? If the very nature of the intended item didn't exist as perceived by both parties, it leans towards substance. If it's more about attributes or potential, it leans towards quality. Step 4. Conclusion. Based on that analysis, if you conclude the mistake was only about quality or judgment, like the fast horse, the contract generally stands. The party who made the better assessment wins. But if you conclude the mistake went to the very substance or nature, meaning the thing they thought they were contracting for essentially didn't exist in that form, then the contract is likely voidable, as it was in Sherwood.
That's a great breakdown. It really highlights that contracts aren't just words on paper. They rely on these deep, shared understandings about what's actually being exchanged. But it leaves me wondering, what if the mistake had gone the other way around with Rose?
And that's the perfect place to leave our listeners with something to think about, building directly on Sherwood's logic. Imagine if Rose Thixian had been sold as a guaranteed valuable breeder for, say, $1,000. Both parties believe she's fertile. But then, after the sale, the buyer discovers she's actually barren, completely useless for breeding, worth only $80 as beef. Should the buyer now be able to rescind the contract using the same Sherwood reasoning? Could they argue that the substance of what they intended to buy a breeder cow had no existence? Does this principle cut both ways equally? Or does our intuition about who should bear the risk shift depending on whether the mistake makes a thing surprisingly valuable versus surprisingly worthless? That question really gets to the heart of risk allocation in contract law.